May it please the court. Before I go back to the to the question I finished on, which was power of the court in Morocco to order a return, can I just touch again on my arguments about the need to look at the 1996 convention as a scheme, as an overall scheme? Because in that context, I do ask the court to bear in mind that before that 1996 scheme came into force in England, no order made by the Moroccan courts would have been directly enforceable in England. Of course, in any hearing in England, the courts would have no doubt taken account of any orders made, but they wouldn't have had any direct force. And at best, the court would have been applying the Ray J welfare approach, if it had jurisdiction at all. Ray J itself, there was a clear jurisdictional route that's spelt out in paragraph 19 of Ray J. The position, however, in relation to Morocco has now wholly changed, because orders made in Morocco must be enforced, whatever the English court may or may not think about welfare considerations, save for that limited public policy ground. And I also ask the court to bear in mind that Article 7 of the 96 Convention, which is what directly engages Article 11 in a wrongful removal or wrongful retention case, has similarities with Article 10 of Brussels II Revised, the provision in Brussels II Revised which continues the jurisdiction of the courts in the country from which a child's been removed, if it's another member state of the Brussels II scheme. But it has very important differences from Article 10 of Brussels II as well. And the most important is that it doesn't incorporate by reference anything like Article 11. It doesn't have that restriction. The English courts still have open to them their general powers that they would have had in any event. I turn then to that question of, does the Moroccan court have a power to order a return, to order someone who is subject to the jurisdiction or in relation to a child over whom the court has jurisdiction? And we know that the court had at the relevant time the jurisdiction over this child because it was the court of habitual residence, and insofar, even if habitual residence had changed, it still had jurisdiction in relation to the child by virtue of Article 7 of the 96 Convention. So my submission is that by virtue of that alone, it must have had the power to order a return. Even more clear if one looks at Article 5 of the 96 Convention, Volume 1, Tab 4, Memory Stick 733, which itself must have domestic effect in Morocco, just as it has domestic effect in the UK.
Well, that says that as a matter of international obligation, Morocco wouldn't ruffle any feathers if it asserted the power to order a return.
Well, it doesn't ask
the question that you're asking yourself about Moroccan domestic law rather than its international.
Yes, but just as the whole of the 96 Convention is now part of our domestic law, must it not equally, under the scheme, become part of the Moroccan domestic law? And under the Moroccan domestic law, Article 5, the judicial or administrative authorities of the contracting state of the habitual residence of the child, and that's continued in Article 7 if the child's been wrongfully removed, have jurisdiction to take measures directed to the protection of the child's personal property. And we know the extended meaning of protection by looking back at Article 1 and Article 3. So even if and insofar as the Moroccan court didn't otherwise have the power to make orders, it has that power under the 96 Convention itself, in my submission. But,
a jurisdiction provision gives you jurisdiction. It doesn't tell you what your domestic powers are.
yeah, but it gives jurisdiction to take measures directed to the protection of the child. So if the protection of the child...
It could be that your law didn't let you do that.
I'm sorry, my lady, what?
It could be that your law didn't let you do that.
Yeah, but if a protective measure that's required is a...
What's the applicable law?
The applicable law is under Article 22, which would be Moroccan law,
Exactly.
if it was the Moroccan court. And of course,
well, under Article 15, it's going to be English law here, isn't it?
English law is the applicable law here.
Now, I was asking you the applicable law under Article 5
Yes.
would be Moroccan law, wouldn't
It
it?
would be Moroccan law if it was Morocco that was making the order, yes.
That's the point I was making to Mr. Turner. We do not know whether
Yes.
Morocco is a dualist or a
But
country. We
there
can
is,
make
of
a good
course,
guess, though.
there is, of course, a principle that I think my lady referred to in Ray J. I could find the paragraph if needs be, and it's referred to in a number of other cases, that there is a presumption of English law that overseas law is the same as English law unless and until the contrary is proved. I'm sure I can find that given time in Ray J, because I always quote it from either Ray J or Mansour and Mansour is the other source of that.
I didn't make it up.
No. So I would rely on that presumption of English law insofar as that presumption is not rebutted. But also I rely on the fact that the father here made an application to the court in Morocco for the residential custody of the child, the physical custody of the child. And of course, implicit in that, since the child was at that time overseas from Morocco in England, to obtain that would have necessitated a direction that the child come back to Morocco. Now, the Moroccan court refused the father's application, but it didn't refuse it on the basis that it had no such power. It refused it on two bases. Number one, that there was that it wasn't established that it was more than a temporary move, but more importantly for our purposes, on the basis that, as it were, in any event, the father couldn't, under the Moroccan domestic civil or religious law, have the custody of the child because he didn't have an appropriate female as part of his household.
Being unable to see whether it was a temporary or permanent move might suggest that it really is sometimes quite difficult for the home court when the mother, usually the mother, sometimes the father, has gone abroad and remains abroad, with the child who remains abroad, quite difficult to get to the bottom, even of really rather simple things.
Yes. My Lord, that might be a situation which in many, if not most, relocation cases would justify the English court exercising its power. But here, it could not conceivably be said, could it, that there was no opportunity to make an application to the Moroccan court within the time, the delayed time, that the application had taken to come before the English court. We know that the application wasn't even made to the English court till more than 6 months had elapsed from the removal of the child. Whether there be good or bad reasons for that, it's a matter of fact. And we know for sure that an application could have been made to the court in Morocco because an application was made to the court in Morocco. So it answers the question, and that's why I say Lady Justice Black was entitled to say, on the particular facts of this individual case, without seeking to lay down any general rule or principle, insofar as the 96 Convention enables or does not prohibit an order for return being made, Article 7.3 and Article 11 weren't satisfied on the very individual facts of this particular case.
But how far do the father's failings, if that's what they were, bear on the question of whether it is necessary in the interest of the child to make a protective order under Article 11? Supposing you had an entirely feckless father, this one clearly isn't, But supposing you had an entirely feckless father who simply did nothing, would that affect the question of whether the Article 11 jurisdiction ought to be exercised?
Well, of course, it would delay, would even affect the Ray J jurisdiction, because one of the various matters that would be weighed in the balance on the Ray J jurisprudence would be the question of how hot the pursuit was and how settled the child had become. And one would have to take that into account as one of the circumstances. And I submit that equally one would have to take into account in deciding here whether the necessity, the urgency, whether the protection that was desired, that was desirable, was engaged in the circumstances where there had been that inevitable settlement that will have taken place, I think it was, 14 months before the hearing before Mr. Justice Roderick Wood, 6 months before the proceedings were started, 14 months before they were concluded at first instance. We know there was then some quite extraordinary delay after that. So, my Lord, I do say, as I've always submitted in this case, that this is a case where ultimately the end result turns on the individual particular facts. And one certainly can't say that in every wrongful removal or wrongful retention case, that despite the new 96 Convention scheme, every wrongful removal, every wrongful retention case must satisfy Article 12. Because there wouldn't be any point in Article 7.3 and Article 11 it being made clear that those are restrictive provisions, that you only have that particular power. If every removal case, you wouldn't need Article 3 to say, in a case of removal, you can only make such orders as come within Article 11. I paraphrase, of course, what the article actually says. So what does Article 11 mean? It must mean something, and it must mean that there is a case-by-case analysis that's required. What is the test that's then required? Well, I dealt with that in answer to Millay just now. Of course, one then turns to the applicable law, and if England has jurisdiction at all, the applicable, if it satisfies Article 11, the applicable law is the domestic law, and the domestic law then would be presumably the welfare. It would have to be a
But
welfare.
you can take account, exceptionally, of the law of another jurisdiction with which the child has a substantial connection.
Yes,
That's 15.2, I think.
yes. So I do say that Article 7.3 and Article 11 must have some meaning under this scheme. And they must have a meaning that restricts what would otherwise be the wide general power. So one asks here, for what is the urgent and necessary protection sought? Is it for interim contact? Is it for a return? And can it be said that it is necessary, on any view of things, in a situation where the opportunity has not only existed to make an application to a court which is capable of making speedy decisions, as we know from the decision of Mr. Justice Roderick Wood, because he said so, but has heard an application? And what happens then if there's to be a clash? If the court in Morocco says, no, we're not making an order for return, for reasons such as, for example, it would offend our local law if the mother were not to return herself, because no one can compel the mother to return. And Mr. Justice Roderick Wood specifically envisaged the possibility that the mother might not return. And indeed, one of our complaints on the substantive Ray J jurisprudence merits is that his lordship never explained anywhere how he balanced that against other factors and took account of that. And we know from what the child told the Kafkas officer that the child didn't expect the mother would return to Morocco if he returned to Morocco. So there we would have the English court, in effect, bringing about a child's return to Morocco, where the Moroccan law would not permit the child to live in the father's household without appropriate female presence. One would then have a clash between the two jurisdictions. It could work the other way as well. What if the English court thought that on a Ray J approach, a return on a summary basis wasn't appropriate, but the court in Morocco said, we want him back here. And that's why, under the scheme of the 96 Convention, the Home Court is put in charge, save in a situation of true necessity and urgency. And clearly, there's a distinction, we submit, to be drawn between the paradigm examples of the use of Article 11, where there is a medical emergency, and even the situation where it's been used in conjunction with the 1980 Hague Convention to ensure that upon touchdown in the home jurisdiction, the measures which are immediately needed, the protective measures, are then in place. And if we look at the Ray Y case, we see that, I think it was in paragraph 10 of the Ray Y case, Lord Justice Thorpe spoke of the 96 Convention as complementing the 1980 Convention. We have the supplementary use of the Convention in the Australian case that's in the authorities as well, in Bundle 10, the A case. So used in a rather different context there. There'd been an application for relocation of a child to Germany. The court in Australia had permitted that relocation. The mother had obtained an order for relocation. The father had issued an appeal, and the question was whether the mother should be permitted to take the child to Germany in the interim, pending the hearing of the appeal. And the court decided that yes, she could, as long as that was accompanied by orders made pursuant to the 1996 Act, requiring her to return, if called upon to do so, by the Australian court. In other words, if the father's appeal should succeed. I mean, that's the essence of it. But if we look at at Article 50 as well in the Hague, the 96 Hague Convention. I'm trusting that the court knows where the document is now, but it's tab 4 in Authority Volume 1, Memory Stick, page 742. And the court looked at that this morning with Mr. Setright, and my Lord Wilson made some points in relation to it. But of course, it envisages the complementing of the 1980 Convention with the 96 Convention in countries where both apply. But in any event, it does nothing to reduce the impact of Article 7.3 and Article 11. While we're dealing with priorities, we'd better look at Article 61 of Brussels II Revised, which has been referred to. That's in tab 5 of Authorities Volume 1, and the article is to be found on Memory Stick page 761. Well, perhaps we'd look at Article 60, first of all, which precedes it. So we see that the Brussels II regulation takes precedence over a number of instruments under Article 60, including, at paragraph E, the 1980 Hague Convention. So Brussels II takes precedence over that, but as we know, the Brussels II Convention actually supplements in various ways and the 1980 Hague Convention. It certainly doesn't conflict with the 1980 Hague Convention. Nothing in Article 60 about the 1996 Convention, but we find the 1996 Convention in Article 61. relation with the 1996 Convention. As concerns the relation with the Hague Convention of 19th of October 1996 on jurisdiction, etc., this regulation shall apply. So this regulation, the Brussels II regulation, has priority in two situations. Firstly, where the child concerned has his or her habitual residence on the territory of a member state, that's member state of the Brussels II revised scheme, which is not the case here unless the child's habitual residence had changed. And even if the child's habitual residence had changed, that still wouldn't negate the effect of Article 7.1 of the Hague 96 Convention. But the Court of Appeal explained carefully why they did not think there was much to be made of any argument that the child's habitual residence had changed between the date of the removal and the time of the proceedings before Mr. Justice Roderick Wood. And Lady Justice Black explained that quite carefully at paragraph 30 of the judgment in the Court of Appeal, why she proceeded on the basis that there had been no change to English habitual residence. Although I say any change wouldn't have affected Article 7 of Hague, but it would have had a potential relevance, another complicating factor read together with Article 61, if there'd been jurisdiction anyway under the Brussels II revised regulation. So first of all, well, no priority, that it's not engaged there, so no question of priority there. B, as concerns the recognition and enforcement of a judgment given in a court of a member state. Well, Morocco isn't a member state of the Brussels II revised scheme, so no application there. So section 61 in my submission is irrelevant. And then we see under Article 62, the agreements and conventions referred to in Articles 59, 60 and 61, and we know that the 96 Convention is referred to, shall continue to have effect in relation to matters not governed by this regulation. So the 96 Convention continues to, or has, its freestanding effect, and it is part of our domestic law. I mentioned that earlier on the question of relocation power. Can I just touch on that quite briefly? My friend referred you to what Mr. Justice Roderick Wood said in Appendix 1, memory stick page 329. Mr. Justice Roderick Wood, at paragraph 31 of his judgment, refers to the evidence, the written evidence that had been given by the expert in Moroccan law. And his lordship was there addressing the question of whether there was a power to order relocation, to permit relocation, if the mother had gone back. The Statute of Family, the Moroccan Code of 2004, does not mention in any of its articles the relocation to another country, which is absolutely right. So there's no overt power of the child wanted for custody by the parent. Article 178 of the same statute, however, states the custodian mother does not lose custody over her child if she moves permanent to a different town in Morocco. Well, of course, there's a world of difference between moving to a different town in Morocco and moving abroad. If such lawsuit to relocate the child to another country is brought, the family court, in giving its decision, may consider the child's best interest in the ability of the non-custodian parent to visit the child's visitation rights. It seems to me, says his lordship, from the last subparagraph recited above, the attorney clearly contemplates the existence of a suit to relocate to another country and makes it abundantly clear the relevant test is the child's best interest. However, what Miss Moore wanted to ask the expert about was paragraph 179 of the Moroccan Code, which is in Appendix 2, at memory stick page 648. It starts at 647, Article 179. The court may, at the request of the public prosecutor's office, and of course it's one of those jurisdictions where the public prosecutor in effect represents the interests of the child, or the child's legal representative, include in the custody decree or any subsequent decision an injunction prohibiting travel by the child outside of Morocco. There was, so far as we are aware, no such injunction in the order in relation to the mother's custodianship of this child, which of course had raised the whole question of whether it was a wrongful removal. But I'm stuck with that, the finding of wrongful removal, without the prior consent of his or her legal representative. The public prosecutor's office shall notify the competent authorities about the injunction so they may take all measures necessary to guarantee the execution of this decision. And then, importantly, over leaf, in the event that permission to travel outside of Morocco with the child is not obtained, the custodian may petition the judge in charge of expeditious cases to secure such permission. Permission shall not be granted until the judge has ascertained that such travel is temporary and the child will be returned to Morocco. So that raises the question of, yes, you may be able to remove the child from Morocco, but can it be more than temporary ever? And of course that would engage very significantly considerations raised in Re J, one of the welfare considerations as to whether it's in the child's best interest to order a summary return, is the question of whether there would be power in the local court to permit the mother to remove the child on the sort of considerations that we would regard as appropriate. Can I just deal with the question of, as it were, children of where one doesn't know their jurisdiction, public law type cases, what would happen if we had such a case here? It will be dealt with, I submit, under Articles 13 or 14 of the Brussels II revised regulation, which caters for such situations. But what I say about the second core contention, the question of the application by the Court of Appeal of the relevant principles to the particular facts of the case, is that, bearing in mind the application that the father had had the opportunity to make, it clearly could not be said in this case that the requirements of Articles 7, 3 and 11 were satisfied. Or alternatively, at the very least, I submit that a conclusion by the court which decided that matter, and it hadn't been decided at first instance, so the Court of Appeal wasn't effectively the court concluding that, it was a decision that was reasonably open to that court on the facts, and not a decision that should now be interfered with by this court, because it would be a factual evaluation, not a matter of principle, and this court should only be concerning itself, in my submission, with matters of principle, not factual evaluation, because the Court of Appeal was, in effect, performing the role of the factual evaluation there, because it had not been performed by the judge at first instance. And that, I say, is a principle. Of course, it can be said that this court is in as good a position to do that, but that's not the point. The point is one of principle, that this court shouldn't interfere with evaluations by a lower court as long as they were within the bounds of what was open to that court on the particular facts of the case. It shouldn't be, as it were, taking a second view of the evaluative exercise. There are 4 important matters that I do seek to highlight from the background history. Now, of course, the general background history is set out fully in the Statement of Facts and Issues, and of course I'm not going to repeat that. But I want to emphasize, first of all, that the child who is the subject of these proceedings has now been living in England since the 14th of September 2013. That's just over 2 years and 2 months. And that is in the context of what is supposedly the English court taking urgent protective measures, necessary protective measures. We know there was a delay between the removal of the child from Morocco in September 2013 and the commencement of the English proceedings in March 2014. So not a great deal of urgency demonstrated there. There was then a massive delay.
Well, he was applying to the Moroccan court, as you made clear.
Yes, I certainly don't seek to blame the father, and indeed I say he did what was
you say there's not a great deal of urgency. He thought to himself, I'll get a switch of residence first,
yes.
And he didn't.
It was even then some time after the Moroccan court. And I understand there may well be practical reasons for that. Of course I understand that.
But as Lord Wilson pointed out, the court's not actually concerned with scoring or deducting points as between one parent and another. Its question is, is there an urgent need of the child?
Of course. But, my Lord, the point is that although it can be said that the child is here, the fact is that the court that should be in control and the court that should have made the decision in the first place if there was to be a removal from Morocco absent consent was the court in Morocco. That court is readily accessible to the left-behind father. So in that sense, the Moroccan court, the home court, is the better court, one might have expected. And of course, that's exactly, isn't it, what Article 10 of the Brussels II regulation envisages as well, that whatever the English court may do, or whatever the requested court may do in relation to the Hague Convention, if it refuses to make an order for return and refuses it on the basis of an Article 13 consideration, then the home court can trump that by making its own order, because that's the court that's in ultimate control.
Well, that's what Mr. Justice Wood intended, because by what he said at the end of his judgment, that there should be that he was satisfied that the interests of the child required the child to be taken, returned, where he could re-establish a relationship with his father, and then the Moroccan court would take the long-term decisions.
No, with respect, it's the other way round, the way Article 10 works. It's if the English court declines to make an order for return, the overseas home court can insist on a return nevertheless.
Yeah.
But we don't have that mechanism here. Instead, we have the mechanism of Article 7.3. The home court has first bite at the cherry, unless it's necessary for the protection of the child in a situation of true urgency. So that's the point. But I make this point about the delay for a different reason, because there was then massive delay following in the Court of Appeal. We know the judgment was reserved for a very long time. The application for permission to this court for permission to appeal wasn't even pursued expeditiously. It was some considerable time after the decision of the Court of Appeal before it was pursued.
No. Mr. Setright asked swiftly for permission to appeal, and I think it took 6 weeks for the Court of Appeal to turn it down.
Well, my Lord, the history of it is trammelled in my written objections to the application for permission to appeal, and I commend the court respectfully to the details set out in there. What would normally happen in my submission, and what almost inevitably happens, is the Court of Appeal hands down its judgment in draft, as the court did here, together with a request for counsel to send in typographical corrections, and also inviting the court to inviting counsel to draft an order and to send in submissions about any consequential matters that are not agreed. We readily agreed a draft order in this case. No request, no application at that stage to the Court of Appeal for permission to appeal. It wasn't, I think, until the 27th day after that that an application was put before the Court of Appeal for permission to appeal, and at the same time the letter sent to the registrar of this court saying that an application was being made for the Court of Appeal for permission to appeal, which is a condition precedent, an application being refused before the application can be made to this court, and that an application for legal aid to pursue the application in the Court of Appeal was being made at the same time. And it wasn't then, and yes, there was delay by the Court of Appeal, your Lordship's absolutely right. But then it was further time after that before legal aid was then obtained to pursue it here. So
We've got the picture.
So it was the delay. The reason I make all this is not to score any points in effect, but to simply say that if an order were to be made now that would have the effect of the child being sent back to Morocco on a summary basis without a full welfare evaluation, giving the time and the inevitable settlement that's occurred during that 2 years and 2 months, then I submit that that would amount to a breach of that child's rights under Article 8 of the ECHR and no doubt the various other international instruments. So,
Mr. Forgive me if I've not got a point I should have done. You referred us a moment ago to your objections to the grant of permission to appeal and said the history in it. I'm not sure I've read that. Where is it in the papers?
It's in the SC003 form in the core bundle.
Yeah.
Right.
You'll find that the history set out. The form starts.
Yep, got it. Core bundle, page 32.
Yeah. And then there is the history recited in the document annex starting at page 36.
Thank you very much indeed.
So my submission is that even if this court were to decide that the Court of Appeal was wrong in relation to one of the critical matters, the two matters that I've started to address, and the matter were to be remitted for reconsideration below, the consideration below ought, after this time, in any event, to be on a full welfare basis if the father is actually seeking an order for return to Morocco, as opposed to trying to sort out contact, realistic, sensible contact arrangements. And I make it clear that my client, as I understand, has never had any objection to the child visiting the father in Morocco or the father visiting the child here, save that, of course, while this matter has been pending for realistic reasons, of course, there have been difficulties both ways. The mother, of course, has anxiety about going to Morocco until the matter is resolved. But as a matter of principle, there is no difficulty that's going to be likely. Of course, that gives rise to the question of the consequences of the Court of Appeal decision. My learned friends have suggested that they certainly suggested in their application for permission to appeal, and to some extent have pursued that in their written case, that the decision of the Court of Appeal leaves a lacuna, leaves this child, as it were, in a black hole. And we say that is just simply not right. And we have explained in our written case from paragraph 67 onwards, that's memory stick 214, precisely why we say there is no lacuna, because either the court in Morocco still has jurisdiction and there is nothing to stop the father even now going to Morocco, obtaining an order which would be enforceable in England, or if it be the case, as may now seem likely after 2 years and 2 months and integration into the community in England, if first of all the child's habitual residence has by now changed to England, and if the other conditions in Article 7.1 of Brussels II revised have been satisfied, as it would seem likely they have been once these proceedings are determined, then the English court would undoubtedly have its the full range of options open to it that it would have if a child is habitually resident here, unrestricted by Article 7.3 or Article 11. So either the Moroccan court still has full power, which will be enforceable, or the English court has full power. There is no lacuna. The child is perfectly properly to be protected by court orders if and insofar as that be necessary.
Can you just explain on what basis the English court would have full power, given Article 7.1?
If we look at Article 7...
and on the basis that you are stuck with the finding of wrongful removal.
Well, my lady,
On that basis, I appreciate you don't like it.
If I'm stuck with the finding of wrongful removal, there has been, as a matter of fact, a removal without the permission of the other parent or in breach of custody rights, because the definition of wrongful removal in Article 7.2 is precisely the same as the definition in Article 3 of the 1980 Hague Convention. So if we look at Article 7.1,
7.1b, don't you?
7.1b, yes.
No request for return lodged within that period.
Still pending.
Yes, still pending.
So if these proceedings are concluded by our dismissing the appeal,
then the English
there's
court has
nothing
full
pending.
jurisdiction. That's it.
That's what I wanted you to explain.
That's my point. So my second point arising out of the facts, the first having been the length of time the child's been here and the effect that that should have on any sort of summary process. The second point is that I've already accepted I'm obliged to proceed on the basis of the correctness of the finding of wrongful removal. But what's important, as I've already said many times, is of course that the father did have the opportunity to and did take the opportunity to make an application to the court of the child's habitual residence. And as I say, that's important, an essential part of the history, because this case, if this case does turn on its facts, as I submit it does, and I've already drawn attention to the differences between the scheme under Article 10 of the Brussels II regulation, where jurisdiction is preserved for the home court, but not limited for other courts, and Article 7.3 and 11 of the different 1996 Hague Convention scheme. So it was clearly possible to get a determination from the court. How then, I ask, can it be said that it's urgent and necessary for the protection of the child for this court subsequently to make an order? And I've referred already to Mr. Justice Mostyn's conclusions, even when the Hague Convention jurisdiction is open, and the court will find the cross-references for that in paragraph 27 of our written case. The third point in relation to the history, to which I draw the court's particular attention, and it's already become apparent from the discussion today, is how it was that the jurisdiction issue came about. You know, it wasn't as a result of anything raised at first instance. One certainly can't criticise Mr. Justice Roderick Wood because nobody aired the point. It was an entirely new point, no authority on it or of any sort. And it was Lady Justice Black who, as one can see from the history, the supplemental history that's recited in our position statement, who was obviously thinking about it and thinking about it further and started the ball rolling. I raise that because it takes me to my important fourth point, which is that Lady Justice Black had nevertheless, before that had been fully thought through, nevertheless given permission to appeal on the substantive grounds. And I draw attention to that, not only because of the point that I made a number of times in our written case, of course, that fairness requires if the order of the Court of Appeal is set aside, there should be a determination by some court somewhere of those substantive grounds, or alternatively, as we've accepted again in our written case, sending back to first instance and a redetermination de novo. But the other reason for which I raise it is that various assertions have been made in connection with the present appeal about the significance of the other findings of Mr. Justice Roderick Wood, not the finding of wrongful removal that I'm stuck with, but the finding of Mr. Justice Roderick Wood that it was in the child's best interests for a summary return to be effected. And I can give an example of how that has been prayed in aid. First of all, starting in my learned friend's application to this court for permission to appeal, and it's in the core volume in their written application, Memory Stick 14. Where they say, paragraph 5, the effect of the decision of the Court of Appeal was that whilst the key conclusion of the trial judge that it's in the child's best interest to return to Morocco, and further his finding that for so long as the child remains in this jurisdiction, he's unlikely to have direct contact with his father, remains undisturbed, the English court is now prevented from taking any step to give effect to that finding. Well, that has been further pursued, that point, in the appellant's written case at paragraph 74, that's Memory Stick, page 181. The point about contact raises different points, but it's sought, as it were, I seek to characterise it by saying it's putting a bit of spin on it, effectively, saying that, well, Mr. Justice Roderick Wood, in his undisturbed finding, found that the child's best interest demanded a rapid return to Morocco. And therefore, here you are, making jurisdictional findings that prevent that return.
I understand that point. Nevertheless, the Court of Appeal did proceed on the basis that it could determine this issue without disturbing the conclusion that it was in the best interests of the child to go back, which leads me to ask you, is there any other area of the law, family law, where the court concludes it's in the best interests of the child to do X, but I have no jurisdiction to do it?
Well, there are certainly, I can't for the moment quote chapter and verse, but one can certainly envisage situations where a court might not have jurisdiction to do that which it thought was most appropriate.
Well, you certainly have jurisdiction to send a child back when you're absolutely convinced it's not in the child's best interest to send the child back.
Yes, quite, absolutely. One's forced to under the 1980 Hague
Well, the
Convention.
child would have to be
for example.
here for a start, wouldn't it?
Yes.
But the Hague Convention surely is set out in terms of perceived welfare.
It is.
Ultimately,
So
yes. I mean,
that might be an answer to my
yes.
lady's.
I mean, we've
point.
been through that ground in the Rayee
Well,
case,
exactly.
of course, where the
logic of-
ultimate
The logic
focus.
of your argument, isn't it, is that Mr. Justice Wood had no jurisdiction to make that finding, because you say the jurisdiction only arose if it was necessary to embark on these matters, and the availability of the Moroccan court meant that it was not necessary to embark on them. Ergo, he ought never to have made the finding, and the fact that he did make them shouldn't assist the other side. And
Well,
I think is the logic of your argument.
I do, but I also go a little further because my Lord says the Court of Appeal left Mr. Justice Wood's finding about welfare undisturbed. Well, with respect, what the Court of Appeal actually did was, before it heard the appeal, it stayed the order. That stay was never removed, and the court then found that Mr. Justice Roderick Wood had no jurisdiction to make any order at all. So, putting it at its highest, the matter of welfare remains undetermined. So it is, as I would characterise it, spin to start the exercise on the basis that the welfare of the child demands the return of the child, demands a return, but for jurisdictional reasons the court can't do it. What
is not spin is to ask the question whether there is a jurisdictional power if the court does reach those findings, irrespective of whether it was right in this case or not.
And then, if
that was Lord Wilson's question, is
yes.
there a parallel case?
I can't think of a precise situation while on my feet. As I say, I do say that if and insofar as there was the power to make the order, we still have undetermined the question of whether that power was correctly exercised, because that was the original substantive appeal that remains undetermined. So one should start from the neutral basis that we don't know what was in the child's best interest in terms of return, because there were good grounds of appeal against that have not been determined. It was unfortunate and that the Court of Appeal didn't deal with that in the alternative, because they could have said, and one knows sometimes courts do say, well, I find on X side for one reason, but even if I'm wrong on that, I'd find for another reason. And they could have said one way or the other. We would uphold Mr. Justice Roddick Wood if he had jurisdiction, or in any event, we would find that he exercised such jurisdiction if he had it wrongly, but they didn't. So we're left in that undetermined situation. And the court knows my concern that having gone to the Court of Appeal initially on that ground, we then end up losing without that ground, those grounds ever being determined. But secondly, the spin of starting from the assumption that that was a correct conclusion when we don't know. And the point's also made, curiously, on behalf of the Air Centre in paragraph 6 of their written submissions on what's supposed to be neutral assistance on the principles. Can I then just briefly touch a little more on the first of...
So just before you do...
Of course.
So have I got this right? Therefore, it would follow, does it, that the structure to be followed by a first instance judge when faced with an application of this kind is to ask him or herself, first of all, whether there's a necessity in terms of a necessity come to the English court rather than going to the foreign court.
Yes.
If the answer to that question is there's no necessity, then he shouldn't embark on considering whether there is an urgent need for protective measures. If satisfied that there is putatively a necessity for protective measures, then stage 2 is to ask whether there is. And then stage 3, once he's satisfied that both aspects of jurisdiction are made out, is the question how he should exercise them on such welfare analysis as he thinks it appropriate to conduct.
If indeed there, well, yes.
So it's a three-stage process.
Because the applicable law, if the power under Article 11 is properly exercised, is domestic law, which would be a welfare test, absolutely. And it may or may not be in an individual wrongful removal case, depending on the particular circumstances, that Article 11 is satisfied. It is interesting, I comment in passing, that in none of the examples given in the Lagarde report or in the practical handbook directly touch upon a power to order a return as opposed to making orders which supplement and support an order for return which is made under some other jurisdiction. I had said, I think, in the written case that there was a first question raised about whether Article 11 was even capable of engaging a return order. And I said that in my written submissions on the basis of Article 11.2 of the Convention. And I suggested that because Article 11.2 speaks about measures ceasing to have effect, that may cast some doubt on whether an order is right at all. That was a bad point. I readily concede that for two reasons. One of them, that which was explained by my Lord Wilson this morning, that Article 11.2 doesn't mean that the court can only make orders that lapse. It's talking about where a court has made orders that lapse. And also, on reflection, it's also apparent that if my concern was right in that situation, it would always be right, also be right in relation to the paradigm situation of the medical emergency, which is also a one-off, not a continuing state of affairs. So if and insofar as I sought to cast doubt on the possibility of a return order coming within Article 11, I withdraw that contention. But can I go back to that first question, the question of the jurisdiction? And I started off by saying, if and insofar as the English court has any other power other than 1996 power, then it's restricted or inhibited by reason of Articles 7, 3 and 11. And if and insofar as it doesn't, then there is that restricted jurisdiction given. I don't understand my learned friends really to actually challenge that analysis. We've set out the detail of the analysis by comparison and contrast with the various routes by which a return order can be made in our printed case. But what we've sought to make clear is that one must bear in mind the different schemes under the different conventions and instruments that are potential candidates. Some countries are members, I've said, of both the conventions. Some are members of both the conventions and the Brussels II revised regulation. We know the 1980 convention has no application, so that knocks that on the head as a possibility. We've looked at Article 61 of the Brussels II revised regulation about priority. One could then go through the exercise in A&A of casting an eye over the 1986 Act, the 1986 Family Law Act. The relevant parts of it are in Authorities Volume 1 at tab 7. One needs to look at that with a finger also in A&A, which is in Volume Authorities Volume 7 at tab 53.
Well, talking about the Family Law Act, if the English court has jurisdiction by virtue of the 96 Convention, well, then that is Section 2.
Yes. That depends on whether it's a Part 1 or...
Well, assuming it's a Part 1 order for the time being.
Let's assume it is,
Yes.
although I submit it.
Yeah. It has jurisdiction by virtue of Section 2(1)(a). But under Section 2(3),
We've got the inherent jurisdiction.
No. Well, yeah, I'm talking about the inherent jurisdiction because that was what this case started as. Under Section 2(3), the court can't make an inherent jurisdiction order of a particular type.
That's right. It's got to be the particular.
Yes, unless it either has jurisdiction under the 96 Convention or neither of those applies, neither Brussels II or the Hague Convention applies, but the child is present. That's condition. That's in Section 3. Now, I'm assuming that you would say that when talking about the Hague Convention not applying, that covers a case, that can only cover a case where the Hague Convention is not around at all. In other words, it's not synonymous with, I'm sorry, I'm putting this very badly, but it's not synonymous with you don't have jurisdiction under the Hague Convention.
Oh, no, no, no.
Because it couldn't be...
Oh, no, no, no.
Yes.
Because Hague Convention, the 96 Hague Convention is a freestanding piece of
Absolutely.
domestic
So it
law.
either, if it applies, and it does apply,
Yes.
as between England and Wales and
Then
Morocco,
irrespective of
the
86 Act.
that simply has no application.
Absolutely.
Yeah.
Yes, so it's not excluded in any sense by the 86 Act because it has freestanding effect. But we have the same question about whether it's a section, looking at Section 2 of the 86 Act, we have the same question as in A&A about whether it's a Section 11A order. And the argument there was on whether the particular type of order was in fact an order made, an application made under the Children Act for a specific issue. It clearly isn't no other way of coming within there. And for the same reasons as this court found in Ray A, I would submit that in this case it's not a Section 11A order either. But even if it is...
So you're saying it's not to order a child to be returned to Morocco is not a specific issue order?
It's no more a specific issue order on the facts of this case than was the order for a return of a child to England in A&A. And that was for the reasons that Milady set out in paragraph 25 of A&A.
Thank you.
So if one looks at paragraph 25, the same line of reasoning, I submit, applies. But even if it were within Section 11A, the court can't make such an order unless it has jurisdiction under the Council regulation or the Hague Convention. So that brings on the Hague Convention here, and it brings on Section 7.3 and...
Well, those are the
Section
provisions
11.
to which I was referring, yeah.
And then under Section 2.3 of the 86 Act, shall not make a Section 11D order unless... Well, we don't even get to the unlesses because it's not a Section 11D order.
No.
But again, if it was, it would, again, be one would refer to the 96 Hague Convention. Of course, the amendment to the 96 Hague Convention came into effect at the same time as the convention in November 2012. And that's why it wasn't mentioned in the A&A recital, because when the A&A case started, that was before that particular amendment.
So if you're wrong and there is jurisdiction to make a return order in these circumstances and perhaps in every circumstance of a wrongful removal or retention, what are the criteria that govern the court's consideration of whether to exercise it?
Well, the first question is whether Section 11 is satisfied, and wouldn't be right for me to try and put a gloss on the wording of Section 11.
That's the
That's the trouble.
The question that you were asked, Mr. Turner, was assuming that there is jurisdiction.
Oh, assuming
What are the criteria on which the court should operate?
Assuming that there is jurisdiction, then it's the Ray J criteria in my submission, because of the applicable law provision in the 96 Convention.
Which basically says the welfare of the child is paramount, but there are plenty of situations in which the welfare of the child demands a speedy return.
There are some which demand a speedy return, others which don't. The sort of factors you take into account include, but are by no means limited to, how long the child's been here, the degree of settlement, as to how extensive the welfare inquiry needs to be, whether the home location would permit, has a relocation jurisdiction, all of those matters. Our criticism of Mr. Justice Roderick Wood in essence was that he didn't conduct that balancing exercise. He didn't reason why the return outweighed those factors. He didn't explain how those factors were brought into the equation. He didn't examine properly the relocation, or he was erroneous in relation to the relocation jurisdiction. He in fact treated the whole thing as if it was tantamount to a 1980 convention application when it clearly wasn't. And indeed we were submitting in front of the Court of Appeal that in certain of the matters it wouldn't even have satisfied the requirements for an order of return under the 1980 Convention. But I'm not going to rehearse that in detail now. Before I leave Brussels II, I should, I suppose, raise a possibility, whether it helps me or not, but so the Court's fully informed. It's one that I did raise in front of the Court of Appeal, which is Article 14. Because, of course, we knock on the head Article 8, Article 9, all the articles from 8 to 13 relatively easily. But Article 14, if the child isn't habitually resident in any member state, and that on the Court of Appeal's conclusions would be the situation here, then, yes, page 751, the memory stick. So if Articles 8 to 13 don't apply, jurisdiction shall be determined in each member state by the laws of that state. Of course, there are, I suppose, then, two laws which are potentially applicable. There is the 1996 Convention, which is now a law of the UK, but also there is the old protective jurisdiction that was discussed importantly in A&A. The obligation owed to the subject by the state. Now that obligation would be owed, of course, to this child, because just as the child in A&A, this child is a British national. And in any event, quite apart from that, unlike the child in A&A, this child is physically present in the territory of the state. So the protective jurisdiction, as I understand it, would also apply even if the child wasn't a British national, because being within the territory of the state is entitled to the protection of the state.
It's my fault. I rather lost you here, Mr. Turner. Why are we looking at Article 14? We know from Article 61 that there's no priority given to Brussels II revised. And so we're
Well, Lord, I
it's the
mention it.
1996 jurisdiction or nothing.
I mention it for the sake of completeness, because I say that in any event, that jurisdiction, as we know from A&A, must be exercised very cautiously, and I submit this Court wouldn't exercise that jurisdiction or encourage its exercise in a situation where the primary court of jurisdiction had declined to exercise and where there was adequate time, and unlike the case in Pakistan, where there were going to be problems or potential problems in applying to the overseas court there are no such problems apparent in this particular case. Dealing with the suggestion that's made primarily by the Air Centre that the conclusion of the Court of Appeal or the approach of the Court of Appeal would be non-compliant with provisions such as Article 8 of the ECHR, we would invite the Court to reject that effectively on the same basis as the Court rejected similar arguments in the Ray E case, that the whole purpose of the scheme is, as it says on the tin, the name of the instrument is for the protection of children. If it's being said that it's not being operated in a way to protect children, I come back to my consequences submission that whichever way you cut it, one or other court has full power to make all necessary orders in relation to the welfare of this particular child and to have that order enforced by the other court. So if the English court has jurisdiction to make them, the Moroccan court's got to enforce them. If the Moroccan court's got jurisdiction to make them, the English court has got to enforce them, absent the extreme public policy situation.
Well, actually, the Moroccan court can then come along and say, well, we're the place with primary jurisdiction, and we can order your measures. We can make an order which is inconsistent with your measures, whereupon ours lapses under 11.2.
Yeah.
Yes.
Exactly.
I mean, that would have to be right if the Moroccan court was the court of primary jurisdiction.
If they didn't like what the English court did under Article 11, they can trump it.
Yes. But I come back to my question about, well, where is the boundary to be drawn? Because Article 11 and the restrictions imposed by Article 7.3 and Article 11 must mean something. Clearly, Article 11 is, as the commentators say, a derogation from the primary jurisdiction. So is it then to be said that in every case where there is established to have been a wrongful removal or wrongful retention, in whatever circumstances, no matter how long ago, Article 7.3 and Article 11 are satisfied, come what may? And we submit that clearly can't be right, and therefore there has got to be a rather more nuanced factual assessment, and that whichever side of the line one looks, in this particular case where there was not only the opportunity to make an application to the Court of Primary Jurisdiction, but the opportunity was taken, then it cannot be said that it's necessary in this position, in the context of the way the words are used in Article 11, because of course, like other international instruments, it will have the words will have an autonomous meaning, so one has to construe them in context. My second core issue, I think I've addressed pretty much already. Lady Justice Black, in performing her analysis of looking at the word urgent, which I've submitted was perhaps not the most important word. I suggest that perhaps necessary was more important than urgent. But in looking at the provision of Article 7.3 and Article 11 and comparing it with other similar wordings, she didn't pretend for a moment to be drawing direct analogies. Indeed, she recognised overtly that it wasn't a direct comparison she was doing, but it might throw some light on the matter. And in just the same way, I have referred to the additional case, the Vermouth case in relation to financial matters, not because I say there's any direct comparison, but because one of the points that was made by the Court of Appeal in relation to Vermouth was the fact that, as Lord Justice Thorpe said, it was all about whether you could make an interim maintenance order when the overseas court was the court of primary jurisdiction. It was maintenance pending suit. And Lord Justice Thorpe said, finally, the order which had been made by Mr. Justice Johnson, I think, could not possibly be brought within the definition of urgent cases. As Mr. Mostyn's pointed out, the wife could have had an earlier hearing in the German court. This case, not only could he did have.
Very difficult not to repeat oneself.
I'm sorry.
In a situation like yours.
Yes.
Are you wanting to add anything to what you've put in your printed case about debtor check? You've referred to it in paragraph 58.
I refer to it simply because Lady Justice Black referred to it. And again, I accept that it's not an analogous position, but it may give some guidance. My position is that the natural words are, in the context of the scheme, are the most reliable guide, and that Lady Justice Black was doing no more than doing that. But ultimately, she came down to say, well, how could this case be described as urgent within the relevant meaning when there had already... Well, she didn't say when there had been the application because she didn't treat the father's application as an application for return, but I say implicit in that application was an application for a return. Lords, I think that deals effectively and with my substantive points. Of course, I don't seek to repeat in extenso the points we've made in our written submission, but save where I've disavowed one of them, I stand by those submissions. As far as the submissions made by Reunite about procedure are concerned, well, of course, one can only endorse the fact that these things ought to be dealt with speedily in any event. As to which court they should be dealt with, if they're brought within wardship, they have to be brought in the High Court because that's a reserved type of case. So one doesn't need any direction about that. The rules already require wardship proceedings to be dealt with in the High Court. Contact, as I say, I've already addressed in the written position under a separate subheading. Those are my submissions.
Thank you very much, Mr. Turner. I think that's all the questions that anybody had for you. Mrs. Moore, would you like to follow?
I have nothing further.
Thank you. Mrs. Setright.
My lady, a few points, if I may, in reply. Looking first at my learned friend's submission, in respect of the appropriateness of the father going and making application in the Moroccan court, and my learned friend took the court to the Moroccan law, which allows me to make a submission. And the submission is that this case is an excellent example of the difficulty raised by my Lord Wilson. Not a difficulty, the comment that sometimes it is much easier to deal with matters in the court where the child is than in the court of the state of habitual residence where the child is not. If I look with my lady and my lords at the passages in the Moroccan Civil Code drawn to the court's attention by Mr. Turner, and so to Appendix Part 2, MS page 647, Miss Turner praised this in aid and says, well, there you are. The father could have asked for a return. Well, we say, not so, but the mother could have sought to regularise her situation. So this is an example of the shoe being very much on the other foot on the evidence. The position in the Moroccan Code is that absent a consent, the custodial mother could not have taken the child out other than for a temporary purpose. Would have been wrong so to do.
What about other than for? I don't think she could at all without permission.
She couldn't, but potentially for a temporary purpose, there could have been an authority. If I look with my lords and my lady at Article 179, the court may, at the request of the public prosecutor's office or the child's legal representative, include in the custody decree or subsequent decision an injunction prohibiting travel by the child outside Morocco without the prior consent of his or her legal representative. Well now, so the Moroccan law allows the stable door to be bolted before the horse has gone, an injunction preventing. Now, the opportunity for that didn't arise because this mother, as Mr. Justice Roderick Wood found, acted without informing the father of what she was doing. And so we look at the next words. The public prosecutor's office shall notify the competent authorities about the injunction so that they may take all measures necessary to guarantee the execution of this decision. So exactly as with an English court, there can be notice to airports and other ports to attempt to prevent an exit. But again, that is before an exit. Over the page. In the event that permission to travel outside of Morocco with the child is not obtained, that is this case, the custodian, that's not the father, that's the mother, may petition the judge in charge of expeditious cases to secure such permission. It's plainly not going to be the father who's going to be inviting the Moroccan court to give permission for the mother to retain. That would be ridiculous. Permission shall not be granted until the judge has ascertained that such travel is temporary and that the child will be returned to Morocco. So it's permission for temporary exit. Now, that provision puts into context what actually happened in the Moroccan court when the father made his application and the comments made by Mr. Justice Roderick Wood upon it. So if I now take the court to MS 324 in the judgment of Mr. Justice Roderick Wood, he having found at paragraph 16 that the mother who had actually asserted that there'd been a consent to the removal had produced a version which, as he put it at the end of paragraph 16, falls a long way short of consent, applying the appropriate standard of proof, he went on to deal with the proceedings. There remains no evidence at all that the father could have applied for injunctive relief or any other relief to bring the child back. The potential was for a bar on the removal while the child was still there, or for the mother to seek to ratify. So what happens? The mother, paragraph 17, is legally represented. The father's claim seems to have founded, according to the judgment, the order of that court of 16th January 2014, because the evidence did not establish to the court's satisfaction that the mother had left Morocco permanently rather than temporarily, and because the father didn't propose a female carer. It seems to me, comments Mr. Justice Roderick Wood, that there's the strongest inference from the fact that the tribunal did not know whether it was a short or a long-term removal by the mother, that either she misled them and or they misunderstood. For it has always been her case, that being a reference to what was made clear by her in England, where the court was well seized, rightly or wrongly, of the case. It has always been her case that she was going to leave Morocco permanently with S and not to return to live there, only visiting from time to time. However, I've decided to leave that speculation, strong as the evidence appears to be, to one side and put it from my mind. Of course, if Mr. Justice Roderick Wood had had to determine an Article 11 point as defined by my learned friend, I emphasise, because he says that necessary must be read in relation to the potential operation of the Moroccan jurisdiction, well then perhaps Mr. Justice Roderick Wood would have gone on to make some findings or would have explored further. But it shows the extreme practical difficulty of securing orders or hearings in this case. And dealing with this matter on the facts of this case, I do pray that in aid. I go a little further, my lady and my lords, and this deals also with the position raised by Mr. Turner, who says, well, it's not the fact that the father is without recourse. Even now he can go off to Morocco and get an order. Well, now, in Morocco, he is there. He can't, unfortunately, be elsewhere for reasons explored in the evidence. The mother is here. She has the potential to instruct a lawyer. There's no compulsion upon her, unless that can be exerted by the Moroccan court, to engage. A without notice hearing or decision is unlikely to have any traction. But there is another aspect, and that reflects directly on my Lord Wilson's question about the relative positions of this court and the Moroccan court. Here is an 8-year-old child, well able to express a view. In this country, we have a court that was well able to explore that view. Mrs. Odds of Kafkas interviewed the child, produced a report, the voice of the child was heard. How would the voice of this child be effectively explored and heard against a reasonable timescale and without extraordinary measures being taken in Morocco? Absent, of course, a return. These are not questions, with great respect, which Lady Justice Black considered at all. Yet they are matters which spring obviously to mind, with respect, we say, from these facts. Those are particular areas of reply in that regard. If I move on to a small number of other points, if I may. I promised that I would not deal at any length with Articles 61 and 62 and the question of priority. And it may be that those will not be matters which this court will feel it has to adjudicate upon. And my learned friend says the court doesn't. But with respect, we suggest that he is simplifying somewhat, often a virtue, but not always. We simply point up that the questions of priority and the tensions between the two jurisdictions, the European jurisdiction and the 96 jurisdiction, which may relate to changes of habitual residence, depending on the circumstances, exist. Lady Justice Black avoided dealing with them as unnecessary. In this case, it may be that this court will avoid dealing with them also, but they are there as an undercurrent. And we do invite the court still to read the passages in our written case. I know that my lady and my lords have, but to bear them in mind still when making a determination. Third point, we were asked a specific question about the Hague network of judges. There is indeed a Hague network of judges. Its principal work up until now has been with regard to the 1980 convention for obvious reasons, but its remit is not restricted to that. However, from our researches, which indicate a list of the nations represented, regrettably Morocco is not among them. And so there does not appear to be a Moroccan judge on that panel, which would mean, necessarily and regrettably, that that would not have been a recourse practically available. Mr. Turner, in his submissions this morning, appeared to recognise that a case for urgency and necessity with regard to the child had been made out. But I think that in context, what he's saying is a case of urgency and necessity with regard to jurisdiction has not. And that emphasises the way he puts his case. We say that debtor check, and with respect to him, Mr. Turner is realistic in not seeking to place overmuch weight either on debtor check or vermit, that debtor check is distinguishable both in its own terms on its facts and because it has traction on the different Article 20, not on the 1996. And that if one excludes debtor check, then apart from a reading of the explanatory documents, there is nothing within the four corners of Article 11 itself which compels this court to take the view that Mr. Turner puts forward about the restrictive nature and the limited nature of that part of the convention. Of course, it has an effect, and its effect is delineated by its plain words of the word necessary and the word urgent. But we say that, to use a term overused in a jurisdiction slightly below this one, that an holistic approach to the questions is unavoidable. How can one say what is necessary or urgent without looking at all aspects, without looking at the situation of the child, without looking at the child's interests and the child's needs, and of course, potentially, without looking at what can be done in the other jurisdiction? If I look with my lady and my lords at what Lady Justice Black says at paragraph 77 of her judgment, MS 312. When she deals, if you give me a moment, my lords, do I mean 77? I do, yes. Where she says, it's now clear to me that the impact of the 1996 Convention is far more radical. Matters must first be analysed in terms of jurisdiction, as I have sought to do. We're with great respect, her ladyship there. In any international case, one must analyse the jurisdiction. But we don't say that it is a shuttered, closed-off approach, stage by stage, in the way that Mr. Turner describes, which is a debtor check-informed approach. If the conclusion of this analysis is that the English courts have substantive jurisdiction, it may nonetheless be appropriate to return the child summarily to another country. Yes, but we say, why should it be any less appropriate if the English court does not have a substantive jurisdiction? Indeed, one might envisage that the circumstances might make it more appropriate. But she goes on, depending on the circumstances, the in re J principles may have a place in determining that issue. But, however, they are not, in my view, applicable where the court's jurisdiction is confined to Article 11. Article 11 itself shapes the court's response. The court can order necessary measures of protection in a case of urgency. What those measures are will depend on the needs of a child in any given set of circumstances. Now, in answering a question from the court, Mr. Turner said that if under Article 11 a jurisdiction was given to the English court, that jurisdiction would be exercised on re J principles. Now, therefore, there is a distinction, at least on my reading, and I may be wrong, between the way that Mr. Turner puts the case on what an effective, if I can put it in that way, Article 11 jurisdiction would be, and that of Lady Justice Black. If my learned friend is right, and it is therefore the, dare I call it, unfettered welfare approach of re J, unfettered welfare with the weakest of presumptions. No, I'm exaggerating and I mustn't. But I can remember what I was told about my rigidity in addressing the court on that occasion. But with a rebuttable presumption that in an abduction case, it might very well be in the best interest of the child to return. But otherwise, it's plain welfare. If Mr. Turner is right, then Lady Justice Black was addressing the case wrongly there also, and it may have affected her ultimate decision.
You've discussed what Lady Justice Black is saying, what Mr. Turner is saying. What's Mr. Setright saying?
Mr. Setright says, as I said, there's probably an holistic approach to Article 11, which involves a consideration of whether the measures are necessary or urgent. And that does entail looking in a particular way at the relief that the court is being asked to provide. It may in many cases be a distinction without a difference, especially if one regards the 1996 Convention as having an overarching welfare and protection thrust, and also its avowed intention of bringing into effect the aspirations of the United Nations Convention on the Rights of the Child. But nevertheless, as a discipline, it is a particular discipline. And it would be hard to say whether in some cases it might yield a result that was different from a re-J result. My speculation would be that it probably wouldn't. Re-J, of course, is only concerned with the summary return of abducted children. In the context of the 1980 Hague Convention, for one reason or another not applying, and I remind myself that an example of that was to be found in the decision of the United Kingdom Supreme Court in the Texas case, DL and EL, where after a substantial hearing, the court determined that indeed the 1980 Hague Convention did not apply, but nevertheless that despite a delay, which had inured for substantially longer than any delay in this case, and despite the brave attempts, no, I strike out brave, despite the attempts of those who had represented the mother to say that there was a welfare reason why not, and these all ought to be remitted, to say, well, no, it was in the child's best interests to return, and the return the child must, and if the mother would not go, although the mother was the established primary carer, the child must nevertheless go, which is indeed exactly what happened. That's the way the re-J principle can operate. Would that be different in an Article 11 case? Well, if it was considered urgent and necessary that the child go back, almost certainly no, it wouldn't. And the reasoning process might not be different. But Article 11 applies to a much wider field than does re-J, because it applies to all sorts of interlocutory decisions, ranging from the disposal of property through medical treatment, educational decisions. It could range from the trivial to the life-threatening. This court is concerned in this case with return orders, but the fact is that Lady Justice Black's judgment and the decision of this court on matters of principle is against a wider canvas. And that's why I raise the point about what Lady Justice Black said and that which Mr. Turner said.
That's right. May I ask this? You may already have answered it, I think, but I just want to be clear. If you are the country where the child has been taken, and both countries are Hague Convention countries, then you've got to bring yourself within Article 11, haven't you?
Both countries are 96 Hague.
96,
yes,
I'm sorry.
Yes.
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 Does the inquiry that you have to make under Article 11 involve, as well as the question of whether the order that is being debated is necessary for the child, any inquiry into whether it's necessary that this court should make it rather than the home state? I think you've answered it, but I just want to be sure.
But it may be an inquiry that is appropriately summary.
Oh, that I understand completely.
If I put it in this way.
Yes, yes.
And
otherwise, you're in danger of being completely hamstrung.
Yes, I mean, can I give the court an example which had occurred to us over the short adjournment? I was looking for cases that would survive Mr. Turner's test. And let us suppose that one had a child needing urgent medical treatment in this jurisdiction, where there was a court, let us say a court seized, unlike the Moroccan court, because there's no list, there are no current proceedings in Morocco in this case. But let's suppose there were current proceedings in another country, and that country was in another hemisphere, so there was a time difference, and the court was not sitting, and there was not an out-of-hours judge system. Well, then, logically, on a very quick analysis, it wouldn't be possible. But one would imagine that the fail-safe would be this jurisdiction would do it.
Quite. Conversely, if the operation hasn't got to be carried out for a month, the answer may be different.
The answer may be different. It's a question of degree. Here, in this particular case, there was a good deal of material about the Moroccan law and the Moroccan proceedings. and of the attitude of the mother to the Moroccan proceedings, and of what the judge regarded as a concealment in terms of the removal. And in terms of the delay that had taken place, and one sees that Mr. Justice Roderick Wood commented that there had been substantial delay, part of which was caused by the need for the mother to get her public funding. These things happen. But he plainly took the view, because that would be part of the Re-J analysis, that there was an urgency that matters be dealt with. And he had already had the experience that it was difficult to get to the root of Moroccan law. And there one had seen the attempts that had been made on behalf of the father, albeit to answer different questions, in establishing what could be done.
I may have got it wrong. I'd understood the thrust of your reasoning to be that the existence of the jurisdiction depends on the court in the country to which the child has been taken being satisfied that there is an urgent need for protective measures.
Yes.
It will then, in the exercise of that jurisdiction, think about, is it appropriate for us to do this? Would it be more appropriate for another court?
Yes.
If the question of the availability of another court goes not merely to the exercise of jurisdiction, but to the existence, you would then potentially get yourself into this rather disputatious area of how easy is it going to be to get to another court? What's the listing arrangements like in such and such a town? What's the availability of lawyers? All for the purpose of determining whether there is a jurisdiction in a case where the court's perfectly satisfied that there is actually a need for urgent measures.
That is why I say it's an holistic process. The difference, the principal difference between us and my learned friend Mr. Turner is that Mr. Turner says it's a three-stage approach.
He says you've got to start by examining the availability of a foreign jurisdiction. Only when you're satisfied that for one reason or another you can't get there within a reasonable time, do you then turn and consider, well, actually, is the child in need of urgent protection?
Whereas we say it's all rolled up together. And it may well be that the starting point is to ask, well, are there urgent protective measures needed for this child?
Yeah.
If there are, it probably goes most of the way to answering the question as to whether the court should exercise them or not, as it would in the example that I gave that Lord Hughes commented upon. There may be, to take an other extreme, perhaps there is a need to make a determination with regard to the child's education. And perhaps the matter has been raised many, many months ahead of the need to determine a change of school. It's an important matter. But in evaluate, and suppose that there is a foreign jurisdiction that has been seized, and there's an habitual residence in the other country, but the child is attending a school in this jurisdiction at the moment. The English court would look to see whether it was necessary or urgent in the child's best interests to determine that matter. It might decide that although it was something that was necessary in the child's welfare interest, the element of urgency, and that's why we are not in agreement with Mr. Turner, who says don't look at urgency, don't prioritise urgency. Urgency is an important part of...
Right. I suppose another relevant factor might be this, that in this type of application, it's almost inevitable that there's going to have to be some form of welfare report, isn't it?
Oh, yes.
Now, if you've got to decide, first of all, before you even embark on considering the child's needs, the availability of a foreign court, you've not only got to consider the listing arrangements in whatever country it is and the availability of lawyers, but you've also got to consider the practical implications of that particular court being able to carry out the sort of welfare investigation and over what time scale. In other words, you've got to do a kind of comparative analysis of the legal process of the other court in relation to what may turn out to be the facts of the present case when you get round to looking at them, before you decide whether you can actually look at the child's needs.
There's a smile that came over my face when the words comparative analysis were spoken, because in the Court of Appeal there have been a number of decisions relatively recently which have emphasised the need for a balance sheet welfare evaluation into various questions before, in particular, certain species of public law decisions can be made. And that's it can be, sometimes, a fairly elaborate process. I'm with your lordship with respect entirely, provided that that is done in a way that's entirely consistent with the exercise of a summary jurisdiction, because the key to any exercise of a jurisdiction afforded by Article 11 would be its summary aspect. And that was the only reason why a smile came to my lips.
I'm afraid the smile that came to my lips was, I will be extremely surprised if the Moroccan courts have the benefit of Kafkas to assist them in deciding what's best for the children. But if they do, I'd like to be told, and I'm getting some looks from behind you. Yeah.
Well, they may have something.
Behind me is not necessarily behind me.
I understand that, yes.
That's often the way.
I do understand that. But what we must not do is assume that each court conducts its adjudication of child-related disputes in the same way that we do.
No, that is right. But where that from which all this flowed was my taking the court to paragraph 77 of Lady Justice Black, where she said, in contradistinction to Mr. Turner, if one is utilising an Article 11 jurisdiction, it may be informed by Re J, but it won't necessarily be exactly the same as Re J. And put to the point by my Lord Wilson, we would say that welfare is likely to be the uppermost consideration when it comes to the exercise of such a jurisdiction, because welfare is the driver of that jurisdiction, and welfare will determine how that jurisdiction is exercised. But there will at least be a sideways glance at timescales.
Both the Lagarde approach, the Lagarde report states, and it's repeated in the handbook, that because Article 11 is premised on there being concurrent jurisdiction, the justification for its being exercised is precisely urgency, which in the sense of the delays which would be caused by bringing a request before the courts where the child was habitually resident might compromise the protection or the interests of the child. So unless one abandons Lagarde and the handbook, one does have to consider the whether the alternative would adequately protect the child.
It certainly does say that, and I hesitate to say it's only the report, but it is. And in the end, one looks at the words of the Convention and the purpose of the Convention and its overarching principles. But one also reminds oneself that the Lagarde report does not deal with Article 11 in the context of the return of children.
I think we have that point,
And
Mr. Settler.
that would be a repetition.
Yes, and just as we did rather suggest to Mr. Turner that he should avoid repetition, I think I should suggest to you that Mr. Turner did not sit down a quarter of an hour early in order to give you a quarter of an hour more time to reply to him. You've had your half hour, in other words.
I never thought of that, my lady. But yes, I have. May I have the indulgence of turning to those alongside me to see if there's anything that I've missed? Or anything else I can help the court with?
No, thank you very much indeed.
Milady did ask to have attention drawn to anything about, your ladyship said CAFCAS officers, but there's
Yes.
reference to the assistance of social workers in the context of certain children applications in Article 172 of the Moroccan Code, which is Appendix Part 2.
It's okay, I've got it open.
Right. And Milady, while I'm giving references, the reference I couldn't lay hands on when I was addressing your ladyship about presumption about foreign law is in Ray J, at paragraph 15, memory stick,
It's a
page
fairly trite proposition, I think.
3048. Your ladyship says in brief there, it's more extensively analysed by Lord Donaldson in a case called Mansour and Mansour, which, although reporting family reports, isn't actually a family law case. It was a...
Thank you very much, Mr. Turner. And thank you to everybody who has given us such assistance, particularly the interveners in this very interesting and increasingly important case. We will, of course, take time to consider our judgment, but in accordance with our normal practice in relation to children, we will try at least to give you the answer to what the result is as quickly as possible. The court is now adjourned.